So we'll give people maybe 2 to 3 minutes to hop on. I see folks joining.
Jay, what kind of plans do you have this weekend?
Just going to a state park here. It's kind of a popular spot for us Cincinnatians, Hocking Hills. So
Okay.
nothing special, but it's a good spot at 2 hours drive. So just spending some time in the woods. That's the plan.
Okay. Nice. Nice. What kind of activities are you planning to do? Just hiking or?
Well, it's going to be 36 degrees. So I think we'll probably sit inside our log cabin by the fireplace. But yeah, I mean, it's a good spot for hiking. There's natural cave system and some
Yeah.
small waterfalls. But I've been there probably like 15 times by now. So
Oh, even
uh,
even in the 30s, I'm out there hiking in the morning. Just got to put a bigger jacket on. That's all.
yep, yep.
Yeah.
I thought it's going to be warmer than the 30s Saturday.
Um, was it? 'Cause
I
I
thought,
checked the weather this morning and it was like 30s.
well, maybe there, but I thought,
Yeah.
I'm hoping Saturday here it's
Oh,
55.
yeah, 55 and 34 at night. So, oh, okay. It's actually going to be pretty nice. 55 is definitely summer weather for Ohio. So, so we'll give folks 2 more minutes and we'll get going at 8:05.
Awesome.
All right. I think we'll kick things off. We are live on Facebook as well, and we'll be recording this session as well. So we'll host it on YouTube. That way, folks who missed it today will have recording as well. So on this call today, we have Kevin Maloff. Kevin Maloff is an attorney, and we've worked with Kevin for over 4 or 5 years now. I really enjoy working with Kevin because one, he's really approachable. If I ever have a legal question, I text him and he calls me back right away, which is awesome. Which is unlike most attorneys. Most attorneys will first send you a bill and then they'll hop on a call. So he's very approachable and he's extremely knowledgeable in real estate law, in law in general, but he himself is a real estate investor. He's a developer. So he understands all aspects of law when it comes to real estate investing. And he also offers really good suggestions on creative structuring of deals, which for us as real estate investors is extremely crucial. So with that being said, and without further ado, I'll pass it over to Kevin for a quick intro about yourself. And thanks again for hopping on the call this evening. And then I'll start sharing the slides and we can start going through the content.
All right. Thank you for the kind words. I'll be sure to reduce your bill next time. But in all seriousness, I spent 10 years in the banking industry, working my way up into investment banking, during which time I got married, had 2 kids, was not challenged enough. So I went to law school at night, working full time during the day in banking, traveling to New York and Boston from Cincinnati. And then upon graduation, I worked at Frost Brown Todd as a partner for 20 years. And in 2020, at the beginning of COVID, decided to work with Prominent Title as outside counsel, because during that time, I had invested in a number of properties, as well as developed a number of properties and businesses. So in addition to real estate, I own several restaurants, furniture stores, event centers, etc. And right now I'm in the process of developing Homer Rum in Cincinnati, which is adjacent to my horse farm that I own. As an attorney, though, and as a former banker, I realized, we don't make money until deals close. And nothing against attorneys, but a lot of them are really good, but they also have a really hard time pulling the switch to close. They always see the bad things out there. And as real estate investors and developers, we appreciate that. We try to mitigate risk, but at the end of the day, if we don't close deals, we don't make money. And so with that approach, as Jay indicated, my goal is nothing's going to be perfect, but there's usually a solution out there. And it's coming up with a solution that works both for the seller, the buyer, the investor, the lender. And it's out there. It's finding people that are willing to come up with those solutions. That's what I try to do. Sometimes we can't, but most of the time we can. And so at the end of the day, when I'm representing clients, most of them end up becoming friends. We work in similar circles, and so it becomes personal. My goal is to keep them out of trouble. My job is to always be in front of them, looking for issues that they may not be aware of. A lot of people in real estate, they know what they know. Their problem is they don't know what they don't know. And I don't know everything, but I do know enough that when I spot issues or see challenges, I can advise everybody in advance and at least give everyone an opportunity to look at the situation, digest it, figure out whether they want to proceed forward or not. And that's what I do. Jay, if you want, we can jump into the slides now.
Sounds good. Let me pull up the presentation. There we go.
All right. Real estate and legal considerations. So we can go to the next one. So, one of the first things that, as an attorney, when clients call me, they say, well, we're buying a property, we need to form an LLC. Now, a lot of you out there tonight know about LLCs. Obviously, the whole point of this is to limit personal liability if possible. Now, one of the most important things as we get through this is LLCs are a function of state laws that allow you to operate as a business, minimize personal liability, but in exchange for your right to do this, I stress to everybody that nothing comes without strings attached. And in corporate law, to be a business, you have to act like a business. And too many people go online, and this is not an advertisement for people to use attorneys. What I want people to understand is there's a lot of opportunities to set up your own LLCs today, but with that comes a responsibility to know what you're doing. So for example, just because you have an LLC doesn't mean creditors can't come after you. Most loans, especially in the real estate world, require at least the principals to guarantee the loan. So yes, you have an LLC, but if you guarantee the loan, then the LLC, as to the lending side, provides you with little or no protection because you're joint and severally liable. The second part of this, and I'm going to jump down a little bit to the piercing the corporate veil. So this is the term going back to the early 1900s, where as a result of the antitrust legislation during the Roosevelt era, there are a lot of corporations and a lot of shareholders that hid behind their corporations so they could try to do as much as they could, make as much money as they could. But many times they didn't follow corporate procedure. They didn't act and treat the company like a company. They used it in a way that we call as a personal fiction. And that means they hid behind the company, but did nothing else. And so if you think about the early turn of the century when women still wore veils, the courts came up with a term called piercing the corporate veil, meaning we're going to pierce that veil and go after you personally. And so suddenly a lot of corporations lost their limited liability position because no one used it like a company. So going up above, there are corporate formalities that you have to follow. And a lot of these seem really sort of second nature. You have to maintain separate bank accounts, maintain separate financials, not commingle funds. You need to maintain contracts for all services. So you own a real estate entity, you're going to manage the property. If you have a separate management company, you need to make sure you have a contract to provide those management services. So just saying, well, I own the real estate and I'm also going to manage the property isn't good enough, especially if your management company is a separate company. You need to maintain separate insurance on property, and you have to maintain resolutions that authorize corporate actions. So the resolutions are a big part of this. So when you're a company, if you think about large corporations, they rarely do anything without at least a board of director approval. When you have multiple members that are what I consider managers of the company, there's things that those managers can and can't do. When they can't do something without member approval, we need to make sure that's documented. Too often you get a bunch of people that form an LLC, try to operate like a company, go out and buy real estate, raise money, borrow money, but nothing is documented that approves those actions. Now, why is this really important? At the end of the day, the only time that limited liability matters is when someone sues you. And a good attorney, the first thing they're going to do is they're going to know that a bunch of members are hiding behind that LLC. So a good attorney, the first thing they're going to do is going to figure out how to pierce that corporate veil. They're going to go after the deep pockets. And so they're going to look at each of these things I just talked about. And probably first and foremost, they're going to say, we want to see the bank account statements, and we want to see resolutions that authorize the acquisition of the property, the borrowing of money, etc. And if those things aren't available, if those things never happen, one by one, your likelihood of being sued personally increases. Next slide. So there are two ways that, and I'll get back to some of this, and I'll entertain any questions when we're done. So when dealing with a limited liability company, and when dealing with buying real estate, there's two options. There are asset sales, and then there are what we call stock sales. An asset sale is what I'd say historically 80% of real estate deals are. Those are, you're buying the asset, you're not buying liabilities. The pros, it's a clean sale, there's no residual liability. Buyers can specify the liabilities they want and the ones they don't, i.e., you buy an asset, but there's some maintenance agreements or other types of contracts that have really good terms. You can say, I want to agree to those liabilities, or you can write in the contract that you don't want them. Asset sales don't require as much documentation and they're widely accepted. The challenge in most states is an asset sale, there's a transfer tax associated with the transfer of real estate. In Ohio, an asset sale, you have to record the value or the sale price for reporting to the county auditor. And that becomes the new basis for taxes on that real estate. An example, I had a client that developed low-income housing in the 1980s. He built them, he constructed them, which is the same thing, managed them, and held those for 30 years. The basis in those at the county level was very low. When it came time to sell them, we had assets that the county showed at $8 million in value. The sale price was $45 million. Now, the problem is low-income housing. The rents were low. So the buyer that bought it as an asset sale didn't realize that taxes were no longer triggered at $8 million. Those real estate taxes were going to be based on a $45 million sale price. Suddenly, the rents that were coming in were not even sufficient to cover the increase in the sales tax or the real estate tax. The real estate tax basically went up fivefold. So asset sales in some jurisdictions trigger a new valuation for auditor purposes. Not saying it's bad, simply saying you need to calculate that into your pro forma when you're looking at whether you want to buy a piece of property. Sale information becomes public. There may be times you don't want the public to know. And you also may lose existing contracts that have favorable terms. Next slide.
Kevin, if I may
Yes.
ask a quick question here. Are there certain states where sale does not trigger tax revaluation? I believe, as example, Alabama.
I'm not sure. I do not know the 50 state that do and do not. I would suggest everyone look into that, though.
Okay.
So I just told you some of the bad things about an asset sale. A LLC sale or a stock sale or a membership interest sale. That's when you actually buy the entity that owns the real estate. Now, why would we do it? It's the opposite of why we do asset sales. One, there's normally no transfer tax, no public disclosures. The buyer can acquire the existing leases and contracts, whatever exists at the time of the sale with the LLC that you're buying. You're simply stepping in the shoes of the existing owner, the entity that owns the real estate, the entity that is contracted for different services. None of that changes, only the ownership structure. And in some cases, prices, the sale price that is, does not trigger a new valuation because the real estate is not being sold. Only the membership interest in the LLC is being sold. Now, the cons, the buyer is going to assume any existing liabilities of the LLC. Those are liabilities that are both known and unknown. So if the LLC has failed to pay certain taxes, or the LLC is in the process of getting sued, when you buy the LLC entity, you're buying all of those liabilities that go with it. Buyer also acquires unneeded or obsolete assets. LLC or stock sales not widely accepted in the real estate world, which often leads to delays because as a buyer, you have to educate both the seller and the lender as to why you want to do it. And there's a lot more documentation required because in the purchase agreement, we're going to talk about how do we minimize your liabilities. We often talk about allocating certain liabilities that you do acquire and certain liabilities you may not want to acquire. The next slide, please.
And Kevin, sorry to
Yes.
interrupt again.
That's all right.
We spoke about asset sales and LLC sale. Now, here in Ohio, we do something called drop and swap or entity transfer, which
Excellent
seems to
point.
be like the best of both worlds.
And that's in the next slide.
Oh, perfect. Sorry.
So great thinking though. So how do we mitigate the risk of an LLC sale? In other words, we like the fact that the public doesn't find out. We like the fact that we can avoid substantial increases in real estate taxes. Well, the way we do it is what we refer to locally as drop-down transactions. That's where, and the next slide will go into more detail, but at a high level, we actually create a new LLC that the seller owns temporarily. That allows the real estate to be transferred into the new LLC, allows the buyer to buy the ownership interest in the LLC, but it limits the existing liabilities and allows only those assets that you want to acquire to be acquired. Let's go to the next slide and that'll explain it a little bit better. So we refer to it as a membership interest sale as opposed to a real estate sale. A big part of this is educating sellers and lenders. They just don't understand why you would want to do this. So, one, explain the concept of creating this new clean LLC that's controlled by the seller. Because the seller is going to say, wait a second, I'm not sure I understand this. What are we doing? Well, explaining that we're going to transfer the real property into the new LLC prior to closing. The seller will own the LLC, and the buyer then will acquire the membership interest of the seller at closing. The second piece of this is making sure you're drafting or amending the purchase agreement to reflect this. So the purchase agreement may be drafted as a membership interest sale, but more often than not, my clients generally use a regular real estate purchase agreement. And then after everyone signs it, they talk to me and I explain why they should do a membership interest sale, at which point we have to amend the purchase agreement. There's also a hybrid. If you have an attorney that you work with, sometimes you want to do a membership interest sale, sometimes you don't. Most of my agreements contain a section that allows it to be a real estate purchase agreement, but then there's a conversion section that says the buyer may, in their sole discretion, elect to treat it as a membership interest sale, and contains all the provisions that you would want to ensure that you can actually buy the membership interest. Next slide. So, third, the new LLC is formed by the buyer on behalf of the seller. And we do that because the seller doesn't want to incur any expense. In fact, quite honestly, the sellers are usually pretty grumpy and they think that the buyer's just trying to delay the process or delay it for due diligence purposes or whatever the case may be. But in order to accommodate the seller, we simply say the buyer will form the new LLC, file the articles, prepare a simple, and I mean simple operating agreement. Remember, the seller's only going to own it for 1 day, 2 days, 3 days, 4 days. So no need for a complicated operating agreement because the sole member is going to be the seller. And as I stated earlier on, we're going to prepare a resolution that authorizes the formation of the LLC, authorizes the transfer of the real estate, and authorize the eventual sale of membership interest in that new LLC to the buyer at a future date. Fourth, we then transfer the real estate into the new LLC. So the seller, generally the buyer will prepare all of the documents, but the seller will transfer the real estate into the LLC. But there will also be an assignment of contracts and leases. So remember, the seller owns an entity that owns real estate. The seller owns the entity, and that entity has leases and contracts and a whole bunch of other potential liabilities. This allows you as the buyer to control what stays in the old LLC and what goes into the new LLC. Real estate gets transferred. Leases get transferred. Certain contracts that you want to keep get transferred. Certain other assets you may be transferred. You can assign other liabilities if you want to agree to them. But you also, at this point, dictate what liabilities you do not want. Those stay in the old LLC. Those are retained by the seller. The transfer is then handled by the deed through the title company, usually a week prior to closing, sometimes at closing. And then there's some other documents, bill of sale for equipment, furniture, etc. Next slide. So now all of this has occurred generally a week before closing or a day before closing, and today is the closing. The only thing that we need to do at this point is transfer the membership interest. It's a simple 1 or 2 page document. The seller assigns all of their interest in the new LLC to the buyer. Now, again, following corporate formalities, the seller had a very simple operating agreement. You probably, unless you're buying it solely by yourself, will have an investor group. So you'll need to amend and restate the original operating agreement to reflect the new structure of the investment company. So you may have 1, 2, 3, 4 investors. You may have 50 investors. So this is where you need to work and not just say, we're going to keep the old operating agreement. You need to make sure prior to closing, you've been working with your attorney to draft an operating agreement that is correctly reflects the ownership structure, the management structure, everything that you need for the new entity. And again, you want to execute resolutions that authorize the transfer from the seller and authorize the acquisition of membership interest by the buyer. Other closing docs, some of you may be familiar with: title affidavits, FIRPTA, which is simply a statement that says it's not a foreign entity, tax proration, settlement statements, loan documents. Those all still apply. The only difference is those are going to apply to the new LLC as opposed to the seller's old LLC. Next slide. So we'll stop here for a second. So one thing I don't have in the slides, and I'm happy to answer questions, there are multiple ways that we structure operating agreements. When it's a individual or 2 or 3 individuals acquiring a piece of property, it can be a relatively simple operating agreement. The most important aspect in those operating agreements is to identify, 1, who's going to manage the LLC, and 2, how do people get out of the LLC? In other words, who can sell their membership interest? Under what circumstances can they sell it? What happens if there's a death? What happens if there's a divorce? What happens if there's a bankruptcy of one of the individuals? Generally speaking, when you're entering into an operating agreement with a limited number of people who are not investors per se, but actual active managers of the LLC, you normally don't want a spouse or a relative or the estate coming in and taking over that portion of the LLC. So for those reasons, when creating an operating agreement, you want to make sure you address those, generally what I call the Ds: divorce, disability, death. And normally you simply state that the existing or surviving members have a right to buy out the, what we call the involuntary member that's transferring out of the LLC. There's a second way that these are structured, and I didn't want to spend too much time tonight talking about it, but when you're talking about investors and you're talking about a few, what we'll call the general partners, and then we have a number of limited partners. In those situations, you need to make sure that the operating agreement is drafted in a way that addresses the, quote, control mechanisms within an operating agreement. In other words, when you have a general partner or partners and limited partners, in my case, I normally create 2 classes of ownership. Class A is the general partner or the management class, and Class B is the investor class. the investor class has little or no control over the operating agreement or management of the real estate, except in limited circumstances. The Class A, the management class, has sole control, except in certain circumstances. And you can define those circumstances in your operating agreement. But most importantly, it's identifying, because we're going to get into this raising capital for real estate acquisition section. And before we get there, it's important to start thinking about how do we treat investors versus the management class, because that's going to come out as part of the capital structure. So make notes so you can raise questions after we're done, and I can answer those questions specifically. But when raising capital, one of the first questions I get from clients is, when do I have to comply with the SEC regulated filing requirements, and when don't I? And so I want to be careful. These are not what I'm providing tonight is some general legal analysis as to how things happen. I am not providing per se legal advice. You need to make sure you talk to your attorneys, because every situation is different. But I get many clients that say, I'm buying real estate. I've got 4 friends who want to buy in. Do I have to file anything? And the answer is, it depends. And the reason I say that is, the last thing you want to do is do anything that gives the appearance you're trying to avoid or circumvent SEC regulations. We don't need anyone going to jail or being charged criminally with fraud. But there's a gray area. And I use the term friends for a reason. When I identify a piece of property personally, and I have 2 or 3 people that historically invest with me, there is no per se sale of SEC securities. In other words, I go to some friends, I say, hey, I think I found a property. You guys want to take a look at it? Are you interested in buying it? I don't own the real estate yet. I don't even have an LLC that I have formed yet. And so in that case, there are no securities to be sold because there's no entity that's been created. There's also no assets. There's no historical performance projections. There's no audited or unaudited financial statements. There's nothing. We simply identified a piece of property. That's different than when you identify a piece of property, you have financial information, and you're going out and the key term is soliciting investors. These are people that you probably don't know, or you know at an arm's length, a lot different than friends and family. And in those situations, I strongly suggest that you comply with the SEC regulations. And as you can expect, there's lots and lots and lots of regulations. There are a few, though, that have been made simple. And those are what we call safe harbor provisions, 506B and 506C. Most of the time, my clients use the 506B exemption. And what that says is, you go out and find real estate and you need to raise money and you have potential investors. Well, you can raise an unlimited amount of capital and you can sell an unlimited number of, quote, units or membership interest to accredited investors. The only limitation is you can't go out and do a general solicitation. You can't go on Fox News or on public radio and try to sell your ownership. You can't advertise or market securities on Facebook. You generally can't do any solicitations. The point is, under a 506B, you're generally talking to friends and family and maybe some extended third-party investors. The other limitation is the sales are limited to 35 non-accredited investors. Now, I'm going to define accredited and unaccredited in a minute, but I want to help you guys understand that a 506B solicitation is you've got people that you're raising capital from. Most likely, they're not going to have any control over operations or the business. These are what I refer to as the Class B investors. They are truly just giving you money and relying on the managers to manage the property and hopefully make money for the investors. So 506B, normally in my experience, we're talking somewhere around 50 investors or less. Most are accredited. Most are family, friends, or distantly related or connected investors. And there's usually just a very limited non-accredited investors. Let's see the next slide. So accredited investors, and this is not an exhaustive list, but one, it's a director, executive officer, general partner of the company that's selling the interest. So these are what I refer to as the Class A members. They're the managers. Accredited investors could be in an enterprise in which all the equity owners are also accredited investors. I had this question the other day. Someone said, hey, I've got an investment group that wants to buy into my new property. There's 5 investors. They're forming an LLC. Can they do it? And the answer is, it depends. Attorneys always use that term. And I say it depends. One, are they all accredited investors? If they are, then it satisfies the definition here. If one or more of the, quote, investors are not accredited, that counts against you under the unaccredited. But if you have an investor, but that is a investment group, if they're all accredited, then they're all accredited for purposes of the definition. So most of the time, though, these are individuals. So it's an individual with a net worth or a joint net worth with a spouse or spouse equivalent of at least $1 million, not including the value of the primary residence. That's important. A lot of times I get people that say they have a net worth of $1 million, their home's worth $500,000. That does not get that does not render them an accredited based on this definition. They would have to have $1.5 million net worth. So when you subtract out the $500,000 residence, they're still at the $1 million level. Next slide. So most of the time, although a lot of my clients meet the $1 million accredited requirement, a lot of the times it's this one. It's an individual with income exceeding 200,000 in each of the 2 most recent calendar years, or joint income of 300,000. So you have someone with $1 million or $1.2 million net worth with a $500,000 home. While that may not qualify them, as long as they meet one of these 2, you're good. The last one is a trust. So a trust with assets exceeding $5 million, that's not formed only to acquire these securities. So you can't just form a trust for the purpose of doing this, but you have a family trust that's been in existence, it's got assets, and most important, the purchases are directed by the person who has to have sufficient knowledge and experience in financial and business matters, i.e., it's the grantor of the trust or the trustee. That satisfies the accredited investor as well. But most of the time, it's going to be the $1 million net worth or the $200,000-$300,000 individual incomes that qualify. Next slide. So, and I know I'm going fast, but part of it is because I want to give you guys opportunity to ask questions. The 506B, just to recap, accredited investors, unlimited capital. You cannot solicit, you cannot advertise. And when I say solicit, I'm talking about putting together advertisements and putting things on Facebook. keep this in mind. The more that you draw attention to yourself publicly, the more likely that the SEC is going to see that and come knocking to see exactly what you're doing, whether you're in compliance. I'm not saying that you should do something not to draw attention to the SEC. I'm simply saying if you're advertising and you're putting things out there publicly, just be prepared that you're probably violating the Rule 506B. And so you're going to have to answer to the SEC at that point. Now, before we get in the 506C, I want to explain one more thing, and that is you may have heard the term PPM or private placement memorandums. These are basically prospectus that you put together for the purpose of generating interest. That does not constitute a solicitation. So when you see term sheets or other things like that, a PPM is, and we can talk about it later, it's an exhaustive 45, 50-page document that explains every single risk an investor may encounter. It talks about the resumes of the managers. It talks about projections. It is an exhaustive description of the investment. It's meant to protect the managers, to ensure that they've disclosed everything possible to a potential investor. And it's also intended to protect the managers. So when an investor is unhappy with an investment and they say you didn't disclose something, you can point to it and show them that you provided all that information in advance and hopefully avoid future lawsuits. The 506C, very similar to a 506B, you're also going to have a private placement memorandum. The main difference, or well, the one similarity is you can also raise an unlimited amount of capital. The difference is you can only use accredited investors. A 506C does not allow you to sell to non-accredited. Why do this? Well, the 506C, without going into a lot of detail, provides even more exceptions and some flexible ways that you can raise capital. It allows you to do some additional solicitations. It allows you to do some advertising. But the key is that you cannot sell it to a non-accredited investor, because the SEC makes this assumption. If you're accredited, you know what you're doing, you're responsible with your money. And so if you advertise and you only advertise to accredited investors, you are not taking advantage of someone who maybe isn't knowledgeable, because you've cut out the non-accredited. Now, if you follow a 506C exemption, you have to take reasonable steps to verify that the purchaser's accredited. Most of my clients don't do that. Well, they do take reasonable steps. What they do is they hire a third party to perform verification. And there are companies out there, you can find them. Jay or other people can get you information on that. But these are companies, all they do is perform 506C accredited investor verifications. There's a fee. It is what it is. But again, I look at this as an insurance policy. When you want to take advantage of 506C capital raises and you want to sell to accredited investors, you have to protect yourself and make sure that those people are in fact accredited. And you can do that by hiring a third party. Next slide. So this is the process. You prepare a private placement memorandum, a PPM. It's going to contain, and again, most likely you're going to hire an attorney. I suggest you hire an attorney. It's going to contain required language for every single state in the United States. So the first 20 pages of a PPM contain language from every single state as to what people should or shouldn't do. It contains all of the boilerplate language. The PPM is going to have business models, projections. It's required to provide what are the fees that the managers get? What's compensation that's going to be paid out before you as an investor get any dollars out of the project? The PPM is going to explain all of the business risks that could adversely impact the investment. And it's going to include information on the principals, including experience, conflict of interest, etc. So again, the point of the PPM, if you're an investor, it's going to provide you with all the information, hopefully you need to make a good business decision. If you're the management group who's putting together the purchase of the real estate, this is your opportunity to protect you, because you're going to tell every single person why they shouldn't buy into the business. You're going to tell them all of the scary things that could happen if you invest in real estate. And chances are, if you're an accredited investor, you've done it before, you know what the risks are, and you tell the manager, that's fine. How much do I need to put in? If people get scared because of what you put in a PPM, chances are they are non-accredited, or they're accredited, but they're not people that you want to raise money from. And I'm not saying that they're bad people. I'm simply saying, if you don't have confidence in investing in real estate, there's a really good chance that when you lose money, they're the first to file a lawsuit and say, I didn't know I was going to do this, or I didn't know that the real estate was going to do that. So PPMs, they're intended to be a little scary, but that's okay, because it'll protect you from selling securities to someone who doesn't really belong buying securities. The subscription agreement, that's a document that's part of the PPM, and it's just that. It's their opportunity to subscribe to buy units. It's usually a page, maybe a page and a half, and it simply says, I'm going to buy X number of units for X amount per unit. Here's the total amount. Here's when I have to pay, et cetera, et cetera. Once you issue the PPM, once you receive the subscription agreements from the investors, then you have to prepare the SEC filings and state specific. So you file with the SEC as to whether it's a 506B or a 506C, and then you have to file in each and every state where your investors are from. Now, not disparaging certain states, but it's no surprise that there are certain states that require a lot of work. California, Illinois, New York, New Jersey, and some others. Those are ones that I tend to say are very pro-consumer. And because of that, when you go out and solicit, I'm not saying don't solicit from California or Illinois or New York, but just be prepared that your attorney may end up having to charge additional fees because of the filing requirements in those states, as opposed to Ohio, Nebraska, Kentucky, Mississippi. So once the filings are done, and actually as part of that, you'll be preparing multiple operating agreements like I discussed earlier. You may be preparing one for the real estate itself that's going to hold the real estate, and then you prepare what we call the holding company or the investment company. That's the one the investors are going to own. The holding company is the one that you're going to solicit as the investment company to raise capital. That holding company becomes the sole member of the real estate company. Now, not everybody does it this way. Some people combine them into one. I find, depending on the purpose of the holding company, especially if you're raising capital to buy more than one piece of real estate, then you want to structure it this way. Single purpose entities to hold the real estate, and each of those single purpose entities are then owned by the holding company. And that allows some flexibility, especially if you want to acquire similar situated properties. If you're buying apartments, you're buying self-storage units, you're raising capital, you're going back to the same investors, then you'd want to structure it in this two-tier system. Next slide. That's it.
That's all we had, Kevin.
That's it. So I went sort of quickly. I covered a lot of stuff, but I want to give everybody an opportunity to ask questions, give me hypotheticals so I can answer it.
Awesome. So we do have some questions here in the Q&A box. The first question is from Sapphire. What is your take on land trusts versus the LLC sale or membership transfer?
I'll be honest, I don't do a lot of land trust. So I probably cannot answer that as well as I could. It, again, depending on the geographic area, land trust are more common in certain jurisdictions than others. In the Midwest, almost 99.9% of everything we do are driven by limited liability companies.
Awesome. Thank you, Kevin. And then we have one more question. Does utilizing a disregarded entity, single member LLC, as your investment vehicle to invest in a property that has its own LLC help further reduce individual personal risk and liability? Should you use the same personal LLC to invest into multiple deals? And what state is the best to use as domicile? And this is from an anonymous attendee. So if you want to unmute yourself and add more color to it, please feel free to do so. But that's basically the question, Kevin.
Yeah. So, and I get this a lot, and people think, well, if one LLC is good for protection, why not have two or three? And it goes back to what I said at the beginning: is if the LLC is properly formed, properly managed, all of those formalities are followed. Having multiple LLCs does not make you safer. It does not reduce liability. Now, I'll explain something in a minute, but just on its face, forming an LLC to buy real estate, and then forming an LLC to own the real estate, and then forming an LLC to own the holding company that owns the real estate does not do any more for you than simply forming one LLC to own one piece of property. If you're not following corporate formalities, chances are they'll be able to pierce the first LLC, the second, and the third. And in some respects, given the situation, courts may actually look at that with a jaundiced eye and say, you are obviously trying to avoid liability so much that something must be up, especially if you're not following the formalities. So formalities are the most important. Now, the second point I wanted to make is, that being said, I strongly suggest every piece of property be held in a separate LLC. So I don't want to sound like I'm contradicting myself. The reason we do that is because if someone is able to pierce an LLC, or just you may get a court that's a little more lax, maybe a little more lenient, maybe a little more pro-consumer, they may allow someone to go after a particular real estate investment. And if you have 3 or 4 real estate properties held in the same LLC, they now can go after all 4. Whereas if you have separate LLCs and someone trips and falls or whatever happens, and they want to sue the property where they tripped or fell, they're going to sue a single LLC that owns a single property. They won't be able to go after other LLCs because those have no bearing. There's no relationship. And so putting properties in separate LLCs protects what I consider it's almost the opposite of cross securitization. It creates distinct and separate companies that each own a piece of property, and therefore silos the property from the potential of other people being able to sue and file claims against it. Now, who then gets to own all of those LLCs? It could either be an individual or individuals, and they could form 2, 3, 4, 5 LLCs and they can be the same members of each. Or you can form, like I said at the end, a holding company. The holding company could have 1, 2, 3, 4, 5 members, and then that holding company will be the sole member of each of those different LLCs. Now, once again, it may sound like I'm contradicting myself. The difference is we're not forming the holding company as an extra layer for additional protection. We're doing that more from a tax purpose. In other words, all of those disregarded LLCs roll up into the holding company so that your accountant, whoever's filing, can file at the holding company level. It just makes things simpler. You also then, if you have a management company, that management company can contract with the holding company to provide real estate management services versus having to go to each and every property and contract with each and every LLC. So that's more of an efficiency and a tax purpose as opposed to creating multiple layers just to protect you from potential claims. And then the last answer is there used to be jurisdictions that were more favorable for forming LLCs. A lot of people used to do Delaware. I cannot speak to all of the different jurisdictions. What I can say is, generally speaking, LLCs are widely accepted by every state. Ohio, for example, is no better, no worse than Indiana or Kentucky for purposes of forming LLCs.
Awesome. Thank you so much, Kevin. I do have 3 questions from my side, and hopefully it will benefit the group here as well. One was, we spoke about accredited and non-accredited investors. Now there's another term, sophisticated investor. Would you like to make any comments about what that really means and how can you qualify as a sophisticated investor? I believe there's some sort of an exam that you can pass.
Well, so the term sophisticated investor is it's similar to what I referenced earlier when we talked about a trust, and the trustee or the grantor of the trust had to have certain financial what we refer to as sophistication and understanding deals. So the term accredited is a hard and fast rule, specifically when dealing with a 506c exemption, because that's why there's a definition that the SEC promulgates that says what an accredited investor is. The sophisticated is not per se a defined term. It is true to a lot of government regulations. It is a term that is referenced, but not clearly identified or defined like accredited investor. And so generally speaking, sophisticated does not rise to the level of accredited, but it is an individual who may or may not be accredited, but definitely has a certain level of financial knowledge, which they are then deemed to be sophisticated.
Awesome. Thank you, Kevin. We spoke a little bit about blue sky filings. Many of us, especially folks who have participated in syndications, have heard that term, but what exactly does it mean and what's the purpose of blue sky filings?
I wish I really should go back and figure out who came up with that, because it sounds really important. The truth is, blue sky laws, blue sky filings, all it means is state filings. That's it. So when you talk about filings, you talk about federal filings. That means you're filing with the federal government. When you file blue sky, it means you're filing with one or more states. And so it's simply a term that allows everybody to understand when you say you need to comply with blue sky laws or blue sky filings, it means those states in which you're subject to either filing or they have jurisdiction over you. It simply means you need to comply with the state laws. So blue sky equals state law.
Awesome. Perfect. And last question I had was around the Corporate Transparency Act. Most people on this call have at least one or multiple LLCs. Now, how does this new act impact us, and what are the requirements to be compliant?
It's giving attorneys a lot of work, but it doesn't mean that attorneys have to do it. So the Corporate Transparency Act is an attempt to ensure that financial transactions are not occurring under the guise of other transactions, or transactions are occurring that may or may not be illegal, may or may not be identified as something that could be regulated by the IRS, the Treasury Department, a number of other federal and state jurisdictions. So the whole point of this is giving the federal government knowledge of every single LLC or corporation that has ever been created and is still in existence, or ever will be created and operated in existence. Politics aside, a lot of small businesses feel like it's an encroachment on them, because generally speaking, a lot of the illegal transactions that occur aren't occurring with 99% of the small businesses in the country. But nevertheless, it's a burden now that is falling upon all of these small businesses and a lot of attorneys and small attorneys, because I've, over the past 20 years, have formed hundreds, if not thousands, of LLCs. Question is, am I responsible for reporting every single one? And if I am, I have to reach out to every single owner, or every, what we call a beneficial owner, a BOI, and I have to obtain driver's licenses. I have to obtain all their personal information. I have to complete the BOI form, and then I have to file a BOI form for every single LLC, corporation, et cetera, that I ever did. Now, the answer is I don't have to do it for everybody, but what's important for everyone on the call today, or on this program, is if you've formed it and you've done it in the past, either you or your accountant or your attorney have until December 31st to file everything that needs to be filed, and thereby you're protected. So it has to be filed within 2024. Now, there's a little gray area, but the question is, if you've opened a new LLC, how long do you have to file? Well, it's gray because some will argue you have to file within 30 days of the creation of the LLC. Others say starting in January 1st, 2025, that's when that requirement goes into effect. In other words, I opened 4 or 5 LLCs in January. Did I have to file the BOI and report it within 30 days of January? And our take on it is no. Within 2024, you have to have reported every single LLC, corporation that has or was filed with on or before December 31st, 2024. Starting in 2025, yes, every single new LLC, you have 30 days. And if you fail to file, I can't remember, I think it's $4,000 per day or some extravagant penalty for every single day that you fail to file the BOI after the required reporting period. So very serious, very important. Now's the time to start getting these things filed.
Awesome. Thank you so much, Kevin. If anyone else has any last few questions, please feel free to unmute yourself or drop them in the Q&A box. All right. I'm not seeing anything else trickle in. So I think with that, Kevin, I really want to thank you on behalf of our partnership group, Alex Tam, Jonathan Stanley, and Jason Bake, for joining us on this webinar. This was really insightful. We'll be sharing this recording with all of our investor group as well. So it's going to go out to over 500 people. Really appreciate you hopping on, and thank you all who were able to join on a Thursday evening. It's almost it's over 9 p.m. EST. So appreciate you all hopping on, and have a wonderful night.
Thank you.
Thank you.